committees, we also have a General Assembly resolution, have noted this, that derived from these fundamental rights, we derive an obligation to allow humanitarian assistance when essential needs are not met by the state in the first place. I mentioned as we moved on to this slide that there's a distinction, an important distinction to be made between, sorry, can you go back please? Thank you. There's an important distinction to be made between IHL and human rights law, in that IHL binds state and non-state armed groups equally. There's a big difference in international human rights law. International human rights law is by design meant to bind only states. However, there's now an acceptance and even an expectation that where armed groups are exercising government-like functions and control over territory, that they are also to respect international human rights norms and standards. So a note of caution here that it is not in all instances, and in fact probably in very few instances, that we would say that an armed group also has these human rights law obligations. I'm going to leave it at that for now. The point here was to say there is a legal framework that you can use to sort of support your advocacy and your engagement with parties as you negotiate access and carry out assistance activities and protection activities. And of course, there's much more to say, but I'll leave that for other opportunities. I hope this was clear, and I'm happy to answer your questions. Thank you.
Thanks, Nathalie, for your explanation on the normative framework. And why is it so important to know the normative framework? Because when we are looking at the tools and services we can offer to the humanitarian community to improve humanitarian access, we are looking at a minimum to the three activities that you're seeing on the slide. And one of it is advocacy. So OCHA has recently developed a minimum package of services on humanitarian access, where you have a list of activities, tools, and services we can offer to the humanitarian community. But at a minimum, we think that an OCHA office should be able to implement the three activities. One about advocacy, one about having a coordinated approach on access, and one about monitoring and reporting of access constraints. And when it comes to advocacy, we have a lot of tools at our disposal, such as statements. It could be the humanitarian coordinator statement. It could be public and private advocacy. We can also have typographic snapshots and so on. And when we go through like statement, public and private advocacy, we will always recall the normative framework. So I think it's very critical to know what do we want to use and what we are calling upon. This is the advocacy part. The coordinated approach is something which is critical, especially because our mandate is about coordination. So how can we ensure a coordinated approach of access? We have various tools. We can promote an access strategy, a humanitarian coordination team access strategy. It can be country level, it can be localized, but this will help bringing humanitarian actors together in defining what are the priorities and how do we share tasks and responsibilities in terms of improving humanitarian access. We can also draft ground rules or also joint operating principles or red lines. This would be a kind of code of conduct for the humanitarian actors in terms of engagement with parties to the conflict. What do we agree to do, what we disagree? And this will provide the humanitarian community with a framework for engaging in humanitarian negotiation. We can also set up access working groups at national level, at local level. So we have different tools available to make sure that we have a coordinated approach on access. And of course, it will vary from one context to another, and also on the capacity of OCHA and the capacity of the humanitarian community. So we don't necessarily need to have all these tools available. And we can be creative, but these are some examples. And if you need templates, if you need template reference for access working group, this is something we can share with you and we can help you set up this mechanism. And when it comes to the monitoring and reporting of access constraints, this is something which is critical, as I mentioned before, in order to have an evidence-based advocacy and also to inform our operations, to know where are the priorities and where we need to scale up operation, where we need to do more on negotiations. So to do that, we can have like an incident database, we can have a monitoring of bureaucratic impediments, we can do access severity mapping. So we have different tools at our disposal. We have a list of access constraints that we are looking at in various contexts. So we have more or less 9 access constraints that we are looking at. Of course, some constraints will not apply to your context. So it's critical when you're starting to monitor and reporting on access constraints to look at the constraints that are relevant to your country and making sure that you're not only monitoring the constraints, but also the impact on the population. And this is what is critical for us, is to report against needs and against consequences on affected people. Because if we don't have an advocacy based on the population affected, it would be not as relevant and it would be really self-centered. So this is critical that we are looking at the impact. So these are some of the tools and services available. If you want more, everything is available in additional resources. Now, let me have a look very specifically at humanitarian negotiation. So, what are we talking about when we're talking about humanitarian negotiation? Humanitarian negotiation is our capacity to engage with various parties to the conflict to make sure that we can promote the access agenda and we can promote the humanitarian priorities. So it could be negotiating access to a specific population, it could be negotiating access to specific services. What is important, and you probably know that because most of you are based in country offices, is most of the time humanitarian negotiations are done bilaterally by humanitarian organizations. So you will have the national NGOs doing its own negotiation. You will have the UN doing their own negotiation bilaterally, and the INGO as well. So when OCHA has a comparative advantage to lead the negotiation, and when we are requested by the different members of the humanitarian community, we have a role to play. The added value of OCHA is that we can have different levels of engagement. We can engage at local level, we can engage with our sub-offices, but we can also engage at a more strategic level with the support of the humanitarian coordinator and the emergency relief coordinator. So we have various leverage in terms of negotiation that can be used to solve situations. But what I would like to emphasize is that there is a myth that OCHA would negotiate all the humanitarian access on behalf of the whole humanitarian community. It's not the case. We are supporting other humanitarian actors in their negotiation. We are making sure that we have a coordinated way of negotiating access. We do have a comparative advantage on certain issues, like the negotiation over bureaucratic impediments, when we are doing maybe like negotiating humanitarian arrangements, but we will see that a bit later on. Maybe it's time for another poll, and I'm handing over to Cecilia for poll number 2.
Please, I'm opening a second poll now, so we have 2 other questions for you. You have 2 minutes to respond this time. So are you engaged in humanitarian negotiations first? And what do you think are the key themes or the issues that OCHA can raise as part of the humanitarian negotiations? Okay, so let's see. You've got a few moments more. So here we have 2 participants, maybe more, that are often engaged in humanitarian negotiation, but the majority I can see is either rarely or never. And then the questions about what are the key themes, I think everybody mentioned like all of the above. Some mentioned administrative procedures and acceptance of humanitarian services. So I think there is a good experience around this webinar and a good understanding of what humanitarian negotiation is. But I can confirm that the majority is really either rarely or never. So we have a few that are probably hands-on and are more involved. So thanks for participating in the second poll, and I again hand over to you, Sophie.
Thanks, Cecilia. So going back to humanitarian negotiation, I wanted to share with you some of the issues that we can engage parties to the conflict on access. So the first one is when we want to negotiate some specific humanitarian arrangements, such as humanitarian corridors, days of tranquility, cross-line movements, interagency convoy. I mean, there are a lot of different options in terms of humanitarian arrangement. That would require a lot of preparation, a lot of prerequisites to be made before we can engage in such negotiation. But this is where the humanitarian coordinator, supported by OCHA, can engage in negotiation with parties to the conflict. We can also engage with parties to the conflict to establish and maintain a humanitarian notification system for deconfliction, and we have seen that in contexts such as Syria, Yemen, Iraq, Afghanistan, and so on. So it's the process of notifying parties to the conflict of our location and premises. This also requires a lot of preparatory work and would require, of course, a strong command and control from the parties to be able to be established. This is where OCHA can also support the humanitarian coordinator and the humanitarian country team. As I mentioned, we can also have like a comparative advantage as OCHA, as a coordination body, in terms of negotiating with the authorities on overcoming bureaucratic impediments. So all the visa delay, the custom clearance, the excessive administrative procedures or fees on INGOs, for instance. So this is something that we can, of course, like engage and collect information from humanitarian partners in order to help them not to be exposed in direct negotiation, but to negotiate on behalf of the humanitarian community. We can also, as part of some arrangement and the Saving Lives Together, support for like evacuation or relocation of staff for medical reasons or security reasons. In some contexts, we have established coordination with UNDSS and the INGO community to ensure that we can organize relocation or evacuation of staff. And of course, I mean, we have a role to play in terms of explaining who we are as humanitarian actors. So it's much more than negotiation, it's our continuous engagement with parties to the conflict, explaining how we prioritize needs, how do we identify vulnerable groups. It's building on humanitarian acceptance, explaining what are we providing as services and who we are as humanitarian actors. So we can be here to engage on a regular basis, but also to diffuse tension when they arise because of misunderstanding about who we are and how we work. So these are some examples. It's definitely not exhaustive, but we in the HQ are available to support who you want to engage in some of these aspects and require more guidance. So that's it for humanitarian negotiations. I will hand over the mic to my colleague Natasha, who is our protection advisor, for some protection considerations. Natasha, over to you.
Thank you, Sophie, and good morning and good afternoon to all colleagues. I'm going to spend the next couple of minutes just to discuss some protection considerations related to access. And I also have my colleague Dina, who's based in Geneva, on the line, and both of us are available to answer any of your questions related to protection and are available you in case you need any further support on the broader protection thematic issue. But just to now talk about when we're carrying out access initiatives and engaging with parties to the conflict, it's important for us to take into consideration some protection elements and ensure that protection remains at the centre of humanitarian action and is the overall outcome of the work that we do. So, firstly, we need to ensure that we're adopting a do no harm approach. And basically this translates into prioritising safety and dignity and avoid causing harm. So we want to prevent and minimise as much as possible any unintended negative effects of our interventions, which could potentially compromise the safety of the affected population or increase their vulnerability to any physical or psychological risks. So, for example, excuse me, when we're negotiating humanitarian evacuations, we need to ensure that families stay together and that they're not separated. You should also be aware that during such procedures, men and boys may be taken aside to be interrogated and potentially detained. But when we're evaluating courses of action in terms of access, we need to identify the risks and weigh these against any benefits before taking action. Secondly, we need to adopt protection principles. And I'm not going to go into details of all the protection principles, but essentially, we need to ensure that access is meaningful. And what I mean by this is that people's access to assistance and protection is in proportion to their needs, and they're not faced with any barriers, including any form of discrimination. But at the same time, we need to pay special attention to individuals and groups who may be particularly vulnerable and who have difficulty accessing assistance and services. So these may be minority groups, the elderly, people with disabilities. We just need to ensure that we're also accessing these vulnerable groups and that they're getting the assistance needed. We have to be sensitive also to the needs and the situations and the risks faced by women and girls, and ensure that inclusive and meaningful consultations with the affected populations take place, and that they participate in decisions that directly impact them when it's appropriate. Thirdly, in terms of access, we need to feed into protection, monitoring and reporting mechanisms. So monitoring and reporting is an essential component of our work for evidence-based advocacy and to hold perpetrators accountable for violations. And there are two mechanisms which exist that OCHA are asked to support on, and which we generally contribute to in terms of data on denial of humanitarian access. The first one is the monitoring and reporting mechanism on grave violations committed against children in times of conflict, otherwise known as MRM or MRM 1612, 1612 denoting the number of the Security Council resolution. And there are 6 grave violations that are reported on by the MRM, one of which is the denial of humanitarian access to children. So inside your countries, you may have a country task force on monitoring and reporting, which is co-chaired by UNICEF and the highest UN representative in country. And they're mandated to manage the MRM and often reach out to OCHA to collect information on denial of humanitarian access. The second mechanism is the MARA, M-A-R-A, the Monitoring, Analysis and Reporting Arrangements on Conflict-Related Sexual Violence, which draws on information collected from a variety of sources, including authorities, the UN, and NGOs and local civil society. Now, the implementation of the MARA differs depending on the context, particularly whether it's a conflict or a post-conflict situation. But emphasis needs to be placed on ensuring that any monitoring and reporting on sexual violence is undertaken alongside the provision of services to providers. So in some of your contexts, you may have already come across these mechanisms and have been contacted in order to provide information on access. Fourthly, we should develop common advocacy positions and messages on enhancing the protection of civilians, so that we are not sending mixed messages to parties to the conflict, and so that they are able to play, so they avoid playing humanitarian actors against each other. So messages delivered by different staff on access issues and protection of civilians should be similar. So the message delivered by the CIMCORD officer when engaging with armed actors should be the same as the information in information products. Should be the same that the head of office is messages are using in bilaterals with authorities, as well as information in HC statements and speeches and so forth. So just before I end, I wanted to mention that at headquarters, we're working on developing a cross-functional, providing cross-functional support to field officers on civil military access and protection issues that may be interlinked, and to ensure that field officers receive consolidated guidance and support from the policy branch, the coordination division, and operational division. Its focus and how it will function is still being discussed and defined, but we wanted to give you a heads up on this new approach, particularly to those who are CivMil access or protection focal points in your field offices, because you'll probably be hearing more about this shortly, or may have already started receiving communication on this particular approach that we're adopting at headquarters to better support the field staff.
Thank you.
I'll leave it there.
Yeah, thank you so much, Natasha and colleagues. I would really like now to open for questions, and I know that there is already some questions that are piling up. I noted Sandy's question, and maybe I can simply read it from the chat. But meanwhile, I'll encourage all colleagues to please type in your questions. I think it's the most efficient way. And then I can read them to our SME. So Sandy is asking the difference between operational access, meaning humanitarian access, and access to beneficiaries and community members. And this is the one I have for the moment. So please, colleagues, if you have other questions, don't shy away. Please type them in. So, yeah, maybe you can already take this.
Thanks, Cecilia. I'm not really sure I fully understand the question of Sandy, but I will try to answer. In terms of humanitarian access, I say it's a two-way definition. There is our capacity to have access to people in need. So this means that we will be looking at the constraints that are preventing us to have access to people in need. So it could be checkpoint, it could be lack of authorization from the authorities to go to a specific location. It could be preventing some organization working on some specific activities, such as protection or education, to implement their activities. So this is this way of talking about humanitarian access, which is really like humanitarian-centric, our capacity to have access to people in need. But actually, sometimes some of the access constraints are much more under active populations. So maybe they can't have access to humanitarian services because they will be threatened on the road because you have like IED or mines on the road, or maybe because of their gender, they will not be able to have access to humanitarian assistance. So this is a bit different because maybe we are able to deliver to this specific location, but the population is not able to have access to what we can offer. So this is where we're looking at this two-way definition of humanitarian access.
Thanks, Sophie. I have another question for Mursal Ali Ahmed. So, is OCHA allowed to negotiate with non-state armed groups who are labeled as terrorists by the Security Council and the UN? And maybe I take another one so that you can respond to all them together. Why OCHA cannot negotiate on behalf of all humanitarian actors? Is it not preferable? And if not, why not? This is from Mustafa Boudea.
Okay, thanks for this question. Very interesting one. Maybe let's start with the last one. Should we or not engage and negotiate on behalf of all humanitarian actors? Yeah, of course, we can do it if requested and if necessary. And when there is an access constraint or an access issue affecting the whole humanitarian community, we are most welcome to do that. What I mentioned is that most of the time, I mean, if you're blocked at the checkpoint and you're a local NGOs, before going to OCHA to negotiate on your behalf, you will engage bilaterally and you will start to solve the issue. So when it comes to humanitarian negotiation, I think the first response of most organizations would be to engage bilaterally in negotiation. When sometimes they are not successful, they will request additional support. And this is where OCHA can play a role and negotiate on behalf of humanitarian actors to support or to be a mediator with the different parties to the conflict. And if you have a constraint affecting the whole humanitarian community, of course, we can negotiate on behalf of the humanitarian community. My point is, most of the time, 90% of the time, the first negotiation will take place bilaterally and will take place with the affected actors. And this is where it's important to have ground rules so that we're sure that when we're negotiating, we're not compromising the negotiation of other actors. But of course, if there is an issue affecting the whole humanitarian community, such as bureaucratic impediments, or a specific area with no access at all, we are most welcome as OCHA to negotiate on behalf of the humanitarian community. When it comes to negotiation with non-state armed groups labeled as terrorists or are under a sanction regime, OCHA has developed recently a frequently asked question on engagement with non-state armed groups where we clarify our position. We can engage with non-state armed groups as long as it is for a humanitarian negotiation. And the way of engaging with us is really based on the General Assembly resolution. And when we're engaging, as long as it doesn't include some financial support to engagement with non-state armed group or direct support to engagement with this non-state armed group labeled as terrorists, or listed in the sanction regime, there is no contradiction for us to engage with them. But maybe, I think as it is a legal question, I will hand over the mic to Natalie that maybe can detail a bit more about our engagement with non-state armed group labeled as terrorists.
Yeah, maybe I can also read the other two questions because I believe there is some connection, so maybe you want to take up this one as well. Before you elaborate. So it's why is protection so sensitive for most of the government? Because it affects access. And how can we do better negotiation with the government and work more on the advocacy so that sensitive issues like protection are not isolated? And because we always run into issues, the home issues in jeopardy. In most cases, we're joined by government forces, which affects the neutrality of our work. Sorry for interrupting.
Okay, so maybe Natalie for the non-state armed groups engagement.
Sure. Sophie, I think you've covered it very well, and so all I can really do is agree and support what you've said. And it's, in a way, a question I tried to sort of almost preempt and certainly try to address when I first explained what IHL says about offers of services and the engagement that flows from offers of services. But just to reiterate, IHL explicitly recognizes that impartial humanitarian bodies in any type of armed conflict, whether international or non-international necessarily entails armed groups. So in any type of armed conflict, impartial humanitarian bodies may offer their humanitarian services, whether that is assistance activities or protection activities. And obviously this entails engaging with parties to armed conflict, whether state or non-state armed groups, in order to carry out those activities for people in need. IHL does not care about the labels given by governments, by political bodies to armed groups. IHL looks at whether a group constitutes an armed group for the purposes of an armed conflict, and that's all. It's only looking at very objective criteria, not politically motivated labels. And so IHL per se does not, to put it simply, does not care about labels. That being said, there's a very real tension that we see at all levels, government and international, Security Council in particular, between counterterrorism measures and humanitarian action, and that's an area that we are constantly trying to safeguard to make sure that counterterrorism measures and counterterrorism policies do not impede humanitarian activities. But it's very important to know that from a legal point of view, IHL not only doesn't prevent, but actually allows engagement with any type of armed group that is party to a conflict for humanitarian purposes. And of course, just to say, this is from the legal point of view, that doesn't mean that there aren't very real operational concerns when it comes to deciding whether or not to engage with certain armed groups. Some are probably more readily engageable than others. And also not to deny that there are very real pressures by governments sometimes to refrain from doing that, but that is not a legal issue. It is more about sort of an operational and perhaps a political issue. I'll leave it at that, but we certainly have a lot more to say. We have frequently asked questions document on engaging with non-state armed groups, for example. Thanks.
Thanks, Natalie. I have the last two questions for this round because I see it's 3:29, and I would like to ask if you have another 5 minutes to go. Of course, if any participants have to leave, please do so. But I would like just to read these two last questions. So, have there been instances where bilateral negotiations of INGOs had adverse effects on OCHA-facilitated negotiations? And if yes, how these were resolved? And the last is when the humanitarian access is constrained for security reasons in armed conflict, how and which tools of negotiation can be useful? And then there is another question just came about the role of protection to guide partners, it's about the mandate of OCHA in protection. So, I would leave it at this. So, if you could maybe just take this last round, and then we close the webinar. Thanks for your patience.
So, in terms of adverse effects of bilateral negotiation, so this is happening all the time, and sometimes parties to the conflict use it as a strategy. So they will start some organization to work, put pressure on them, and we prevent them to implement their activities until they compromise on some specific issues such as sharing beneficiary lists or recruiting or using one of their local partners to implement their activities. And of course, sometimes because of pressure, pressure from the donors, pressure from the beneficiaries, INGOs may agree to compromise. And when an NGO is compromising on some of the key principles, then all other organizations working in the area are affected. And we have seen that in a lot of contexts where the parties to the conflict are using it as a strategy to put pressure on organizations. And the only way to solve this issue is to clearly establish red lines or ground rules at capital level and make sure that these ground rules and red lines are known by the different actors so that even though we are under pressure, we have some red lines and the organization can say it's not my red line as an organization, it's the red line of the humanitarian country team. And they can directly report to the HCT saying we're facing issues because we are asked to compromise on the red lines we agreed on. And we're stronger as a group rather than an individual. And this is where I think the ground rules or the red lines or joint operating principles could be critical. I just maybe want to leave the floor for Dina maybe or Natasha for the protection question that were not addressed. So I don't know, Dina, if you want to take one of the questions on protection.
I can just step in to answer the question on OSHA's role in terms of protection. Well, protection is a shared humanitarian system-wide responsibility. And there are different agencies with specific protection mandates, such as UNHCR on refugees and OHCHR in terms of their mandate for human rights. But OSHA also has specific responsibilities to contribute to the protection of affected people, both in armed conflicts and disasters. And also to promote international humanitarian and human rights laws, which Matthew has spoken about. And these responsibilities are set out in the General Assembly Resolution 46182, as well as the Emergency Relief Coordinators, USC mandate, and the terms of reference of the humanitarian coordinators. The ERC, the Emergency Relief Coordinator, is responsible for the coordination of interagency humanitarian action, and this includes both assistance and protection. And specifically, he has a central role for the protection and assistance of IDPs. So, OSHA's primary role is to support the ERC and the humanitarian coordinators fulfill their leadership responsibilities. Therefore, we as in terms of OSHA, and this is in terms of all staff, have a responsibility to ensure that the humanitarian response enhances protection and that we carry out these protection responsibilities. We're currently developing a protection essentials package, very similar to the minimum package that Sophie has developed, a package on protection. And so that is in the pipeline, and we hope to get that out to the field in the coming months. So hopefully that will also provide some guidance for field staff on clarifying some of these questions related to protection. Thank you.
Okay, great. I think we are really at the end of our webinar. I see Dina. I'm so sorry, Dina. We can't hear you, and I don't know what's wrong with that. But I think you have put your comment in the chat, and I'm going to read it loud. So in addition to what Natasha is outlining, we can provide some more information to the colleague who's raising that question and to know the HCSC following session look specifically at OCHA's role on protection. Absolutely. And je vais le dire en français parce que la collègue était francophone. On va traiter la question de la protection dans les unités qui vont suivre, donc dans les unités 2 et spécifiquement la 3. On va aussi traiter de la question dans l'atelier. Donc ça, c'est vraiment l'introduction. So it's really just an introduction because protection is really more precisely treated and covered in the following part of the program. I think I just wanted to share as well, Sophie, just tell me if it's fine. I think this PowerPoint with these useful resources is going to be shared with all of you, along with the recordings of this webinar, so that we can put it on the platform and everybody can access it. I believe that with this, I really would like to thank all of you, all of the panelists, of course, who were we were really fortunate to have the whole policy advice and planning section all together to support us in this webinar, and all participants who, of course, made the space and the time to attend this session. I'm opening the last call for today, I promised. We just would like to hear from you what was the most relevant to you in this webinar, and to what extent you believe this new knowledge has contributed to your understanding of OCHA's core functions. So please take 1 minute, and with this, I want to really thank you all, and wishing you a very good rest of your days. And thank you, Sophie, thank you, Dina, thank you, Natasha, and thank you, Natalie, and have a very good day, you too. Goodbye.
Thank you. Goodbye.